Can director bankruptcy follow on from liquidation for a director? The answer is yes, it can. Now, ignoring matters of misconduct, there are two potentially key straightforward ways that it can arise. It doesn't have to happen, probably not that common, but nevertheless it certainly can. And so it should be something that a director might want to be aware of. I'm obviously talking about insolvent liquidation rather than anything else. First way is personal guarantee. If the director has personally guaranteed any of the company's debts, company goes into liquidation, those debts don't get paid, then ultimately the person who is the beneficiary of the personal guarantee can potentially obtain a judgment and then petition for the bankruptcy of the director personally if they don't satisfy it. The other way which can arise is if, for example, the director's got an overdrawn director's loan account and that does not get repaid by the director to the liquidator and gets settled through the liquidation. What can then happen is when the liquidator, assuming the liquidator writes it off because the director can't afford to repay it, what will then happen, or should conceivably happen, is it then appears as income under Section 415 of the relevant piece of legislation, treated as income tax on the director's personal tax return. And ultimately what can then happen is if that tax is unpaid, the director can then, through a petition of HMRC, find themselves in bankruptcy. So whilst it certainly can happen, that doesn't mean it's commonplace, it doesn't mean it should happen, it just means it can happen. So it's something to be aware of. Questions, queries, concerns, give us a shout. We know insolvency inside out.